Welcome to the Insurance Agents and Brokers Podcast.
Hello, everyone. First of all, let me begin by saying that I hope you're all doing well. Let me introduce myself. I'm Don Bankus, IA&B's Legal and Corporate Affairs Director, and I'd like to welcome you to the April 2024 Primary Agent edition of Don's Discussions. So without further ado, let's get to this month's Q&A. This month's inquiry is, our agency holds a resident producer license in our state of domicile. In other states, our practice is to obtain a non-resident license for only the agency and one of the owners, even though there may be other resident licensees in our agency who also actively produce business in the non-resident states. Is this okay? And the answer is, the practice of simply licensing the agency and a singular designated producer in states where the agency maintains a non-resident license may seem ideal from a purely pragmatic perspective. However, doing so when there are other licensed producers in the agency who also actively sell, solicit, or negotiate insurance products in the non-resident states puts both the agency and those who do not have the requisite non-resident license at risk of violating the respective state's insurance producer laws. Whether you are a Pennsylvania, Maryland, or Delaware resident, licensed agency, with very limited exceptions, the proper and statutorily required way to address non-resident state licensing is to license the agency as well as each and every other producer in the agency who actively sells, solicits, or negotiates risks of insurance located in the non-resident states. As one would expect, the issue at hand is governed by states' respective producer licensing statutes. As to the individual and the agency, the statutes generally provide that a person shall not sell, solicit, or negotiate a contract of insurance in this state for any class or classes of insurance unless the person is licensed as an insurance producer for that line of authority under which the contract is issued. As to the agency, the statutes also generally provide that agencies are expressly prohibited from accepting applications or orders for insurance from any person or securing insurance that was sold, solicited, or negotiated by any person who is acting without an insurance producer license. In addition, these statutes likely also prohibit a producer from acting on behalf of an insurer unless the insurer has appointed the producer. So what are the potential repercussions? Violations of a respective state's statutory provisions can have significant repercussions for both the agency and affected producers who aren't licensed in the non-resident states, including denial, suspension, revocation, or refusal to renew a license, the imposition of a civil penalty or fine, which penalty or fine can be very severe. For example, up to $5,000 per violation in Pennsylvania and up to $20,000 per violation in Delaware. In addition, violators may be determined to have committed a misdemeanor. Final thoughts. While licensing only the agency and a singular producer may have worked to date, and although licensing all applicable personnel can be laborious and expensive, the business of insurance is highly regulated and scrutinized. Failure to adhere to the requirements of the respective states' licensing statutes can ultimately lead to unwanted consequences. And there you have it. If you have any additional questions, please feel free to reach out and contact me at 800-998-9644 at extension 603 or email me at donb@iabforme.com. Thank you very much for listening. Hope you all have a great day, and please continue to be well and safe.
Insurance Agents and Brokers is the premier resource and champion for independent insurance agencies in Pennsylvania, Maryland, and Delaware. For more information, visit iabforme.com. This is not a legal opinion and should not be relied upon as such. The intent is to provide general background regarding the topics discussed, not to provide legal advice. Producers and agencies should consult an attorney regarding specific situations and questions with respect to the topics covered. Neither IA&B or any of its employees shall be responsible for any errors or omissions regarding any statements, nor any statutes, regulations, court rules, and/or government documents cited.